interesting for us to chat about. All right, now, let's say, for example, I make a computer game. I'm not technically very sound, but let's say one of the technically sound persons like Vaibhav makes a computer game. And this computer game it's a baseball game which has 3 basic features. First, if you want to play the game, you have to log in online and pay a subscription fee. Second, this game allows you to play matches between nations. Okay, do you have a baseball World Cup? In fact, my article that I had that's included in the flash drive has cricket, right? So you have a baseball World Cup that is played every year? Yes, no? Right. So let's assume there's a baseball World Cup which is played between nations. So this game allows you to play games between nations, right? So US versus India. Okay, we don't have a baseball team, but let's assume for a minute. Right. So now this baseball, each of these baseball teams has players who play for that country at that point of time. By virtue of the game being online, you can easily update players who is playing at that point of time in the national team, and then, and it also has attributes of each of these players. If the player is a left-hander, he'll be a left-hander in the game. If he's a right-hander, he'll be a right-hander. If he has a specific style, you'll see that attribute in the game. Now the question is, let's say, for example, this game is available online and people start playing it, and the baseball players file a suit for publicity right violation in an Indian court. Would the computer game provider be liable? So if we apply the proportionality test, the test which balances between the impact on the players versus the right to freedom of speech and expression, then you'll have to really see what kind of impact, or which side the balance actually tilts, right? Any thoughts? The players or the games company? Right. So in my opinion, if this case were to be decided by the same court that decided the Daler-Mehendi case, it would go in favor of the games company, because this will be considered to be free speech and expression which is protected, and right to publicity cannot override that free speech and expression. That's primarily because, firstly, this game includes players as a part of it. It's a part of the expression of the whole game, rather than the players being the primary subject matter of the commercial activity in this game. And secondly, players are not being given any flexibility with respect to modifying anything in the game. I mean, when I say player, I'm talking about the gamer. And in many cases earlier, under the privacy law, the courts have held that your right to express in the form of movies, right to express in the form of songs and computer games and so on, would amount to free expression. And unless the interests of the person who is the subject of that expression is impacted in a manner that is very detrimental to that person, then the right to freedom of speech and expression will prevail, right? So this will be the case in this hypothetical. So let's take hypothetical B, where we have, instead of matches between nations, we have matches between clubs. Let's say you can create your own Cincinnati Reds club. You can go online, pay a subscription fee, and by virtue of paying a subscription fee, you also have the right to purchase players. You can purchase Orayo if you want, or you can purchase other players whom you feel you want to include in your game. And each of these players' attributes and their capability to play will depend on their form at that point of time, right? So the computer game is an intelligent game. There is intelligence incorporated into the game. So if that player has performed well in the last season, you purchase him online, he'll play very well. on your online game, he'll have certain extra flexibility in shots or in pitches and so on, right? So what would the court say in this scenario, where a gamer can purchase players and play a game? So in this scenario, there is a direct impact on the right of a player to commercialize his persona. And the game is actually using a player's persona as the primary element of the game, or as a very important element of the game, right? And therefore, the balance in this case would tilt in favor of celebrities, and right to freedom of expression will give way to celebrity rights, and rights of publicity will prevail. What if we modify this a little bit? What if you pay the same subscription fee, but you don't need to purchase players, you can generally select your own players? What would happen in that case? Right? We really don't know. Right? It's the proportionality test is by itself a very ambiguous test, and just like the confusion among various courts in the US today with respect to what amounts to publicity rights and what amounts to free speech and expression, there is at this point of time no clarity under the privacy law, and there will therefore be no clarity when the same principle is applied to publicity right law. By the way, I have to state here that Indian courts, which traditionally have been applying or using UK cases as precedents in giving decisions, have used US cases when it comes to privacy and publicity. In fact, the Daler Mehendi case cites Zucchini and a couple of US district court cases. So Indian courts are tending more towards the US jurisprudence when it comes to privacy and publicity, as opposed to them applying the UK principles. And proportionality test is a test which has been picked up from decisions of UK courts. And my prediction that the court will apply the proportionality test when it comes to a clash between publicity rights and free speech and expression may be proved to be wrong. And the court may end up applying a test that is being applied by US courts, like the predominant use test or the transformative test, or any other test which has been applied by courts in the US. Right? Now that leads me to the final part of this presentation, which is, so there is a lot of ambiguity with respect to the interface between publicity rights and free speech and expression across the world. And I hope Indian courts will learn from the experiences of US courts and courts in other countries and use that as a base or a foundation to come up with a test that will suit a scenario as and when it arises before them, rather than working the wheel from the beginning once again. And secondly, as it stands today, this decision, the decisions with respect to publicity rights have primarily come from the Delhi High Court. In India, we have a High Court for each state, and we have a Supreme Court an appeal from many of these high courts lies to the Supreme Court. So none of the other high courts have actually spelled out the concept of publicity rights, except for the Bombay High Court a little bit in one or two cases, very indirectly. Now, recently, the Madras High Court is the High Court in the south, in the state of Tamil Nadu. They gave a decision which was relating to publicity rights, but if you read the decision even 10 times, 20 times, you will not find the word publicity rights anywhere. Right? So the whole decision was given based on publicity rights, but the judge never mentioned the word publicity rights anywhere. The term reputation of the celebrity was used here and there a few times, which shows the basis in privacy. And the decision primarily depended, though it was a publicity right case, it primarily depended on contractual terms and so on. Right, so therefore I believe at this point of time in India we need a national law. Either it may be a decision from the Indian Supreme Court which is applicable throughout the country, or we probably can use this opportunity in the form of the Right to Privacy Bill, which covers various things, which also covers publicity indirectly in various provisions, to bring in the concept of publicity rights and exceptions to that law. And finally, I am not very comfortable with the courts applying passing off to publicity rights issues, because passing off is a tort which is primarily based on misrepresentation, and applying that to publicity rights cases would expand the scope of the tort to misappropriation, which is obviously a bigger superset, and that will, while celebrities already have a basis in publicity right law, you really don't need to expand the tort of passing off and create more confusion. Of course, I would presume this passing off wouldn't have been applied in this case if there was a counsel appearing from the other side, which didn't happen in the Daler Mehendi's case. Right? So that's pretty much it from me. Thank you.